Good morning and welcome to this session. I have a very easy job of introducing our chairman, who is a friend for many years, and he's also directed me to introduce everybody else. Just okay, you don't want to spend. It'll take 1 minute because that's what the job I've been given. I won't take more than 1 minute. Don't worry. Pranav Sayta, who is the chairman of the session and national leader of the tax practice for technology, communication, and entertainment and services sector. Pranav has been a member of executive committee of IFA branch and a member of managing committee of the Western Regional Chapter of IFA India. More importantly, he is a very regular contributor to this event for many years. Very well known. So welcome, Pranav. Mr. Arvind P. Datar. Arvind is a leading senior advocate at the Indian Supreme Court and at the Madras and other high courts in India. He specializes in taxation and company and constitution law and has written over 150 articles for various journals and newspapers. He is the chief editor of the 10th edition of Kanga and Palkhiwala's Law and Practice of Income Tax. Welcome, sir. H. Padamchand Kincha, as we call him Padam. He is a partner in HC Kincha and Company, Bangalore. Padam has over 30 years of experience in corporate and international tax regime. He has spearheaded the income tax consultancy and litigation practice in his firm. He has been associated with several landmark decisions. He has co-authored several papers for Indian taxation affecting cross-border activities and delivered more than 500 lectures. So it's a huge experience. We have Meyyappan N. Meyyappan is a senior member of the international tax practice at Nishit Desai Associates, a very well-known law and the tax practice firm. Meyyappan completed his Masters of Law, Commercial Law degree from University of Cambridge, where he specialized in international tax. Prior to joining Nishit Desai Associates, he worked in the chambers of Mr. Mohan Parasaran, Solicitor General of India, between 2010 and 2014. And he was involved in some of the landmark international tax and domestic tax disputes in India during this time. Sol Picciotto. Sol is an Emeritus Professor of Lancaster University, a senior advisor of the Tax Justice Network, coordinator of BEPS monitoring group, and the chair of the advisory group of the International Center for Tax and Development, where he coordinates and carries out research on taxation of transnational corporations with specific reference to developing countries. He has taught at various universities and has written several books, including on international taxation. Rashmin Sanghvi, as we popularly call him, Rashmin Bhai. Rashmin Bhai is in practice in Mumbai since 1975, so more than 4 decades of huge experience. He is a partner of Rashmin Sanghvi Associates, specializing in international tax and foreign exchange management act. Rashmin Bhai was a member of high-powered committee on e-commerce taxation in 2000. He was again appointed a member of e-commerce committee in the year 2015. Committee report resulted in Equalization Levy, which is what we are going to talk. This is the subject matter of discussion today. Rashmin Bhai has again been appointed on the e-commerce committee in the year 2016 to improve the Equalization Levy which is going on. So we have some great perspective, I'm sure, coming from Rashmin Bhai. Rohinton Sidhwa. Rohinton is a partner with the New Delhi office of Deloitte Huskins and Sells LLP. He has more than 20 years of experience in public practice, including 1.5 years at Los Angeles office in the United States member firm. During his secondment in the US, he served in India desk for the US member firm. Again, Rohinton has been a regular contributor to this conference and other places. Dr. Vinay Kumar.
So I don't know I don't know. There seems to be some error in the sheet, which...
My apologies.
Yeah. So Dr. Vinay Singh was to join us. Unfortunately, he had to go abroad for something. So in the last 2-3 days, at very short notice, we have pulled in Mr. Rahul Naveen, who has been very kind and consented to join the panel on behalf of the revenue. Thank you so much, sir. Really appreciate your joining us at such short notice.
My apology for that. So this, I think we've introduced everyone. With this, I will hand over the session to you, Pranav, and take it off from here. Thank you.
Thank you so much, Uday, for your kind words of introduction. That has simplified my job. I was otherwise going to skip it given the fact that we've already lost a little bit of time. Very quickly, the way we structured this session is we'll first very quickly give a background and introduction of the way equalization levy has been introduced in the Indian law, the Finance Act 2016, and what it has in store for us. Immediately thereafter, we will also very quickly have a perspective of the background behind the introduction of the equalization levy in terms of the BEPS Action Plan 1 report. And we will then look at some of the international background of how other countries have been dealing with the fact that the BEPS Action Plan 1 does not give a very clear answer to the challenges that were foreseen. And we will thereafter invite Rashmin Sanghvi to give his perspective because he possibly has the entire background of how this has evolved. And then move on to the discussion within the panel. So the presentation part, as you'll see in the program, is split between 3-4 of us. Very quickly, in terms of equalization levy, as we see it, this is a levy introduced by the Finance Act at the rate of 6% on B2B transactions from June 2016. And as you are well aware, what we are talking of here is that in case of a payment exceeding rupees 1 lakh made by an Indian resident carrying on a business or profession. So we are talking of a B2B transaction for specified services. So a payment made by an Indian resident which is for specified services, which currently have been defined to include online advertisements, provision for digital advertising space, so it's a bulk advertising space, any other facility or service for the purposes of online advertisement. That's it. And then we are told in future further services can be notified. And we are told if this payment is made by the resident for specified services to a non-resident, then the equalization levy of 6% of the payment will be applicable. So payment made by an Indian resident for specified services to a non-resident, a B2B transaction only, will be leviable with an equalization levy of 6%. We are, however, told that equalization levy will not apply if the non-resident service provider has a permanent establishment in India and the specified services are effectively connected with that permanent establishment. So it's an either or. Either the Income Tax Act will apply, which is permanent establishment tax under the treaty, or the equalization levy will apply, not both. If the non-resident recipient has a permanent establishment and the payment for services is effectively connected with that permanent establishment, then equalization levy will not apply. The CBDT recently, after the introduction of the equalization levy in the Finance Act, it thereafter released a report which had been prepared prior to the introduction of the equalization levy, although the report became public only later, which essentially has a basket of some 13 services to which the expert committee for taxation of e-commerce had recommended an equalization levy. Out of that, only one, namely online advertisement and related services, has been actually imposed with an equalization levy by the law. But the committee had referred to 13 services on which it ought to be levied. It had also suggested a rate of 6 to 8%, starting with 6%. So the law currently talks of a 6% levy. But the way the report reads, it seems that over a period of time, it will be increased to 8%. If that report is regarded as a precursor to the law, which it seems to be. Moving on further, we are specifically told by certain amendments in the Income Tax Act. The equalization levy is part of the Finance Act. But the Income Tax Act, a couple of provisions have been amended, like Section 10 and 40 and so on. So one Section 10 says that any payment which has been subjected to an equalization levy will not be subject to income tax. So it will be exempt specifically under section 10 into bracket 50 of the Income Tax Act. Also, we are told that if the Indian resident payer fails to deduct and deposit equalization levy with the government, 6% of the consideration as we just described, then one of the consequences is that the payer Indian resident will be denied admissibility of that expenditure. The payment for specified services will not be allowed as an expenditure. As it is, we saw this is only applicable to B2B. So that expenditure will be denied allowability. Also, the Indian resident is subject to penalty, interest, and so on if he fails to deduct and deposit. Also, there are some reporting requirements under the Income Tax Act for the Indian resident. Very briefly, therefore, to explain the concept, we are talking of an Indian company which has all the responsibilities here, although the Indian company is the payer, not the income earner or the recipient of the consideration. All the responsibilities for compliances are on the Indian company. The FCO, which is the service provider, the non-resident, will face a deduction of 6% from the consideration payable to it, but is not liable to any compliances, has no responsibilities when it comes to equalization levy. It will, of course, suffer a 6% deduction, which will be borne by it, unless, of course, FCO or the non-resident has sufficient bargaining power to insist upon the Indian resident that if your law requires in India that 6% be withheld, I am insisting on getting the full 100. You bear the consequences of that withholding, which we call typically a tax protected contract. If that is commercially negotiated, the Indian resident may have to gross it up. But that apart, otherwise, the foreign company non-resident bears 6% tax but has no responsibilities for compliances, etc. In short, Indian company, when it makes payment to the foreign company for specified services, deducts 10% equalization levy, deposits it with the government, also files an annual statement, is liable to interest. All of this is Indian company, is liable to interest and faces a disallowance of expense in case of failure to deduct and pay, is liable to penalty if there is a failure to deduct and pay. Appeal also against a penalty is permissible, which will be done by the Indian company if there is a penalty levied on it, and so on. There is no provision for appeal. So in case some writ, etc. is required to be done, that also obviously will be done by the Indian company. So that's where we are in terms of a quick snapshot of the provisions. Very quickly summarizing, if the payer is a resident and the recipient is a resident, no applicability of equalization levy. If both are non-resident, payer and recipient, again EQL normally not applicable. If the payer is a non-resident and the recipient is a resident, again not applicable. If the payer is a resident, the recipient is a non-resident, but the non-resident has a permanent establishment in India and the specified services are effectively connected with that permanent establishment, again equalization levy not applicable. The situation where it applies is payer is a resident, recipient is a non-resident, and the recipient does not have the PE or whatever. In that case, equalization levy applies. With those few words, let me first hand over the proceedings to Mr. Rahul Naveen for explaining, before we go to the international precedents, the BEPS backdrop to the introduction of the equalization levy, and why do we see a unilateral action of this type from India? Behind what really was the genesis thinking behind introduction of the equalization levy? Mr. Rahul Naveen, over to you.
Okay, so thank you, Mr. Pranav, and good morning to all of you. I just want to start from the backdrop of how the BEPS project was launched. The BEPS project was launched, as all of us know, that there was a political support to the fact that the international taxation laws are broken and multinational enterprises are not paying taxes in either resident country or in source country. So this was the basis of the launch of the BEPS project, and also there was, at a political level, there was a perception that there is an inequity between domestic small and medium enterprises taxpayers and the multinational enterprises. So the BEPS project was started at this backdrop. Now, when we are talking about the taxation of digital economy, so the immediate thing which comes into our mind is that what is the taxing rights of the source country or resident country. So this action 1 has not addressed that to a large extent simply because that was not mandate of the BEPS project. But what the BEPS project has highlighted, that this issue has been brought on the forefront. Now, from a revenue perspective, that is fine. The BEPS initial thinking that at least the MNEs should start paying tax somewhere, because when the pies become small, then there is no taxing right anywhere. So first, the global tax community, the global revenue authority should try to increase the pie, and then think of it that how to distribute it between themselves. So I think that is the second stage where it is coming, and in due course, and the action 1 also says that we will be revising this and we will coming out with some solutions which will be having a better way in distribution of taxing rights between the source country and residence countries. Now, regarding this BEPS project, one thing I just want to say here is that this concern of the MNEs are not paying taxes are for a very long time, and the OECD has published reports in the past also. Day before yesterday, Jeffrey was saying that the 1998 report on harmful tax practices was one of the first BEPS report. And if you see that report, it is remarkable in its foresight. Some of the things which we are saying now, it was said long back in 1998. So what happened but that was not successful. So what happened, what is the difference between those efforts or the TAG reports in 2005? So what is the difference between that and the BEPS action point now? I see two major differences. One is that it has more legitimacy. The G20 countries have joined that, and at every stage, the G20 and the OECD has taken care that the concerns of the OECD, non-OECD economies, the developing countries, they are taken on board. So that is one. And the second very important thing is that it is action oriented. Now the BEPS is not just a report, but it says that you have to take this action and this action. So all the action points have some kind of actions which the countries need to take to implement that. Now coming to action 1. Now the legitimacy has a flip side of that. The two involving large number of countries, that there will be a dispute. The development of consensus would be much more difficult. Suppose it is a report of the OECD country only, then it would have been, the consensus would have been much easier to develop. Now, since it is a report where the larger number of economies have participated, so the consensus was very difficult to arrive at. But still, and I would just mention here that I am replacing Mr. Vinay Singh, Dr. Vinay Singh, but Vinay Singh was attending the OECD meetings, and he was very, very vocal. Somebody told in one of the sessions that India's concerns have not taken on board, but that is not correct. Certainly not in many other action points. Some of the action points I have also participated in the OECD meetings, and certainly not in action 1. And this equalization levy, one of the options of equalization levy came into the report on insistence of India only, because we thought that it was going the path of the TAG report and nothing is going to happen, but we thought that we insisted that there should be something which is which should be included. Some options should be included. Options as action points. Now, some of the action points there are consensus. Everybody has to do that. Like in artificial avoidance of PE, so that is coming through multilateral instruments. There are consensus on some of the other action points, like there are consensus, not consensus on some of the action points. For example, on CFC. So CFC is not a minimum standard, and similarly, the digital point is also a not a thing, but still there are three options which has been given, which is new nexus based on significant economic presence, withholding tax on digital transactions, and the third one is equalization levy. Now, the first two options would have required modification in the income tax treaties, and that would not have been possible in a very short period of time. So, as a transit manner, or as a with a we would like as a India tax authority, revenue authorities, we would like one of the either of the other two options, but that would require modification in the treaty. So, as an interim measures, we have taken this route of equalization levy, because it is outside the Income Tax Act and it would not have required any changes in the treaty. Now, why I am saying this background, because after insisting that digital economy is reducing the tax base of the source country and market economies, and after that doing nothing was not an option. So we had to adopt one of the options, and that is why one of the options was adopted, and this was adopted as early as possible. But this option is far from perfect. There are some problems, both in the terms of the number of services will be increased as the committee has recommended in their reports, and also some of the issues which we will discuss during the course of the panel discussion, some of the issues which have been raised. So the government is very positive in addressing those, and there is another committee which has been constituted. Mr. Rashmin is part of that committee, and maybe you can provide your suggestions on that. But I would say that the equalization levy is still better than some of the measures which has been taken by the other countries, such as diverted profit tax of UK, application of GAR by Australia, or maybe some of the big tax disputes which is happening in India and abroad. So this is a work in progress, and from the revenue perspective, we will invite your suggestions for modifications in this law. But I would just wish to reiterate on the basis of the backdrop is that doing nothing by India and waiting for consensus to develop at international level was not an option. So we have to adopt one of the options, and we have adopted this equalization levy, which I feel that okay, it is not perfect, but at least a beginning should be made on this respect. Thank you.
Thank you, Mr. Naveen. Thank you, Mr. Naveen, for that brief introduction and the basis, logic, rationale, the government's thinking behind introduction of equalization levy. A lot of murmurs have been heard all around as to whether India was justified in taking this unilateral action. Let me come over to Mr. Sol Picciotto, Professor. We have seen even other countries taking some unilateral action, and those unilateral actions are also, in a sense, not going with the consensus, not waiting for other countries and to develop a kind of unanimity behind what needs to be done. Why only single out India for criticism? Can we look at some of the other countries and what they have done, like UK, the diverted profit tax, well-known DPT. We are talking of Australia having come up with MOL. Some of the countries talking of significant digital presence or significant economic presence being equivalent to a permanent establishment. Can you take us through some of these international precedents, please?
Thank you very much, and thank you for the opportunity. Yes, I'll focus mainly on the UK provisions, which I think are really very interesting. I mean, I think it's worth noting that the UK is a strong supporter of the BEPS project. Our Prime Minister at the time, David Cameron, was one of the 3 European countries that pressed for it at the G8 and then the G20. The commitment was from the G20 that the BEPS project should ensure that multinationals could be taxed where economic activities occur and value is created. That was strongly supported by the UK, although at the same time it should be noted that the UK government's mandate to its negotiators included that it should retain UK's competitiveness, which I think did result in some of the outcomes of the BEPS project being significantly weakened, because the UK had already moved to a largely territorial system in 2012, more or less abandoning its rules on controlled foreign corporations. So the UK was, let's say, ambivalent. But what's very interesting, I think, is that the proposals for the diverted profits tax were put forward already in 2014, only halfway through the negotiation of the BEPS package. I think that's the first thing to note. Secondly, the provisions of the diverted profits tax, which was eventually passed in April 2015, so it's already been in force over a year, those provisions really go beyond what you could define as the digital economy. We know that the report from the task force on the digital economy concluded, and I think already the very first report, which came out in 2014, said it's not a separate sector, it affects all sectors. So that I think that analysis showed that digitalization really exacerbated, made worse, the problems that were already identified, the problems that India and other countries, particularly developing countries, had experienced of imbalances between source and residence taxation were already evident, and they've been made worse by digitalization to the point that many developed countries are now experiencing those same problems. And that was the cause of the BEPS project. But as I say, it's interesting that the UK government, one of the principal negotiators of BEPS, already thought that the final outcomes would not be sufficient. So the DPT was put forward. So I'll try and go through, I'm allowed 3 minutes now, the provisions of the DPT. But the first thing to note is that it's a peculiar combination of, on the one hand, quite broad anti-abuse provisions, or broad anti-abuse principle. The provisions say that it has to be reasonable to assume that the arrangements are intended to reduce tax. And then on the other hand, some very, very targeted and highly technically complicated provisions. So it's a peculiar combination. It's also framed in a way that quite clearly is intended to put pressure on companies really not to have to pay this diverted profits tax. The tax is on profits that are defined as diverted in the provisions, and if you're found to have diverted profits, those profits would be taxed at 25%, whereas the UK corporate tax rate has been being reduced from 22 to 20. I think it's now down to 18. It's intended to go to 17, maybe even lower. So the normal income tax rate is significantly lower than the rate if you're found to have diverted profits. Now the provisions, as I say, are this peculiar combination, a broad anti-abuse provision. Clearly the broad anti-abuse provision was put in order to ensure that the tax would be compatible with tax treaties. Just as India, I think, has designed the Equalization Levy as far as possible. We're going to discuss in the panel if it is compatible with tax treaties. Equally, the UK provision is designed to be compatible under the anti-abuse provision of tax treaties. Again, whether it is debatable, but so far it hasn't been challenged in any formal legal proceeding. I say it then has some very complex provisions. Broadly speaking, they apply in two circumstances, and I think it's worth trying to think about those, because it's not limited to the situation that the Equalization Levy targets. There are two. One of them is broadly equivalent, where there are sales in the UK of over £10 million, so there is a threshold similar to the Equalization Levy, I think. All the provisions only apply if the entities concerned are not small and medium enterprises, so it's only targeting the largest companies. And HMRC has said that they are scrutinising in particular 100 large companies. Now, as I say, it applies for two types of situation, and I'll try and summarise it very briefly, but they're highly complicated. The first is for entities lacking economic substance. And entities lacking economic substance are defined as those engaged in transactions between related parties. Again, I should stress I'm really simplifying this grossly, and you have to read if you can, if you want to go to sleep early. Transactions between related parties which result in an effective mismatch outcome. And again, very briefly, an effective mismatch outcome involves producing deductible expenses or reducing income which reduce tax in the UK more than 20% of the tax that will be payable in the related jurisdiction. So if the effect of these arrangements is to reduce the actual amount of tax paid in the UK by more than 20% of the amount that is paid in the related jurisdiction, then that's an effective mismatch outcome. So if the arrangements really essentially shift tax to another jurisdiction so as to reduce the tax by that much, then it's an effective mismatch outcome. And then thirdly, there has to be insufficient economic substance, and this is the broad anti-abuse provision. If it's reasonable to assume that the actions were designed to reduce tax, unless the non-tax benefits exceed the tax benefits. So that's the one set of provisions, entities lacking economic substance. The other is where a non-UK resident is avoiding taxable presence in the UK. I think that's similar to the Equalization Levy. But again, since it was put forward quite early, it's an indication that the UK did not consider that the changes that were going to be made to Article 5 on PE would be very significant. And that's interesting because the chairman of the Working Party leading those discussions was from the UK. So what it says is if a non-UK company is avoiding a taxable presence, in the circumstances where a person, whether a UK or non-UK resident, is carrying on activity in the UK in connection with the supply of goods or services. So clearly that's a much broader test than is in Article 5 of the treaty. A person is carrying on activity in connection with the supply of goods or services. If those goods or services are made by the non-resident entity, and it's reasonable to assume that the activity is designed to ensure that the foreign company does not have a PE. Now, those are the kind of basic circumstances, but then the other tests, the effective mismatch outcome, the reduction of tax by more than 20%, and the insufficient economic substance also apply. So there are those two broad situations. I hope I've summarised it. Now, as I say, that's the UK. Australia, I gather, is going to follow largely the UK approach. New Zealand, I'm told, may be considering it. Other countries may consider a similar approach. Other countries may seem to be considering, at any rate, a broader interpretation of the PE requirement. Some countries have taken, and their courts have supported, I think, a broader approach to the PE requirement, and it's possible that the Article 5 proposals on PE might satisfy some countries. But this, as I say, the UK DPT goes much, much further, both in the provisions about avoiding a PE, but also the other provisions. So I think they're clearly an indication that the UK did not consider the BEPS package really goes anywhere near far enough.
Thanks. Thank you so much, Professor. So as we see the world around us, India is not the only country that is thinking of how does one tax the digital economy, and that the current tax regime or the system is probably not adequate enough, needs a rethink in order to ensure that the digital economy or transactions are brought within the net of taxation. Different countries seem to be adopting different routes. Whether you say that a particular overseas company is avoiding a permanent establishment in India, but what is avoiding a permanent establishment? If technology does not require me to be physically present in another country, then is that avoidance of physical presence or economic presence under the current tax rules or regime, or do the rules or regime need a rethink altogether? So let me quickly invite Rashmin to take us through his thought process on why an equalization levy was required and why he thinks it is completely justified. Rashmin bhai.
Thank you. Good morning, friends. Friends, in next 15 minutes, I'll express my views on why equalization levy, and I will also invite you for the improvement of the existing legislation. And taking from what Mr. Rahul Navin said, let me briefly first tell you, there was an equalization or e-commerce committee. The e-commerce committee presented its report in December 2015. Government of India accepted the report, and in February 2016 we have seen the equalization levy as a chapter in Finance Act. I would repeatedly say that this is work in progress. What has been brought into the law is only a small part of the total legislation required. Recognizing this fact, government has again reconstituted the committee. More or less, most of the members are same. Our task now, I am one of the members of the committee, the task is to make a complete law. As a member of the committee, I cannot tell here what is being discussed in the committee, but my endeavor is that we have got one of the best panel here and we have got excellent audience here. I am inviting all the suggestions and all the criticisms on equalization levy. Whatever is constructive suggestion that, okay, this is the deficiency in the equalization levy and this improvement is required, I will note down all the suggestions and to the extent practical, I'll present it before the committee. But one thing should be clear, that committee has only a recommendation power. We will discuss, we'll make a recommendation, then the report goes to CBDT, then it goes to Finance Ministry secretaries, then goes to Finance Minister. At each stage, every authority puts up its own suggestion or cuts out something from the recommendation. Finally, it is the Parliament which will decide. My point is, I am making an appeal to all of you that we will utilize this discussion to improve the law to the best extent possible. So you please make all your suggestions. The chairman will give at the end of the session some time to discuss. And if this time is also not sufficient and you have some discussion, you can email your suggestions to me. This is for the future. But I'll take you right up to the history of e-commerce taxation. OECD has been discussing e-commerce since 1997. And I very vividly remember in 1998, the IFA Congress at London, I had gone for the first time to an IFA Congress, and I made a statement that permanent establishment is not suitable or not adequate for e-commerce taxation. And when I made that, I mean, today everybody is talking about permanent establishment definition being inadequate. In 1998, to say that was a shocking. And I remember Carol coming to me and said, "Oh, so you are the gentleman who said permanent establishment needs correction." I said, "Yes, madam." She was the competent authority in the US taxation at that time. I was the first ordinary member for my lifetime entering the Congress for the first time. But I said that. And then, of course, the Permanent Scientific Committee also discussed the subject. And as it is, very nicely, very gently, everybody discussed and everybody rejected my suggestion. Then the CBDT appointed high-powered committee on e-commerce taxation in 1999. Within about 14 months, we gave our report. Some of the suggestions, recommendations made by us in the report were, first, existing rules of international taxation are inadequate to deal with e-commerce. And the first target is permanent establishment. That definition needs to be corrected. And there are other important recommendations there. That was published in the year 2001. By 2005, OECD came out with again its report on e-commerce taxation and rejected all the suggestions made by Indian Committee on E-commerce. Now, as the history has it, we normally divide countries amongst COS and COR. we, being India, Brazil, China, we are supposed to be normally the COS countries where sales are made into India, sales of services and goods, and the revenue goes to certain countries which are recognized as COR. I would, for our discussion, say G4, US, UK, France, and Germany, the biggest economies of the world. So OECD in 2005 rejected high-powered committee report totally. Then 2008, the American financial crisis came that spread into Europe. By 2010, a lot of countries suffered very badly. Then the G4 started recognizing that these MNCs are avoiding tax by abusing the gaps, the loopholes in the existing system of international taxation. And the Britain was the first country to take aggressive steps. Google was getting billions of pounds of revenue from Britain, was not paying adequate tax in Britain, and hence Britain came out with Diverted Profits Tax Act. And it was now not India. India had no voice in OECD. OECD itself took up the BEPS project. And the main reason was Google, Starbucks, Apple, these companies avoiding the taxes. Within BEPS, the most important report was on e-commerce taxation. That is why it was given as Action 1. In the year 2013, they said within 1 year we will come out with e-commerce taxation proposals. The report finally came out in November 2015 and they had no suggestions. Friends, just consider the fact that Action Report number 2 to 15, everybody had got their suggestions. Action points were given, but on Action 1, again there was no suggestion. 1997 to 2015, for more than 18 years, globally people have been discussing e-commerce taxation, and at the end of the day they came out and saying we still need 5 more years. Somewhere around 2020, we will give a solid suggestion. As has been said in the past, academicians can go on discussing, but government has to act. Government has to pass assessment orders and government has to collect tax. And you can't wait for 20 years to come to a conclusion. So India appointed e-commerce committee. E-commerce committee made a recommendation that this is how the tax must be levied. The theme of the e-commerce committee was very clear. We want to cause minimum difficulties to the business community. Let us draft the law in such a manner that it is clear, there is certainty, and that people can easily pay up the taxes. This is how the equalization levy came in. It was also known that the time available to us was very limited, so we have briefly come out with a proposal. This proposal has to be expanded into a full law. Hence, I will also tell you, and which many of you know, that after February 16, when the budget equalization levy was presented, whichever conference I have gone, there are several experts ready with their sleeves folded up. We want to do boxing with Rashmin. You have brought such a law. There are so many weaknesses in the law. And in these 8 months, I have heard lot of criticisms of equalization levy. And I am prepared with my answers for each and every criticism. Friends, I have studied this subject for 18 years. And my submission is to understand equalization levy or to understand e-commerce taxation, there is a change of mindset is required. OECD has changed its mindset. What it said in 2005, that there is no change is required in the existing rules. Now in BEPS report, each report starts with the statement that existing rules of international taxation are inadequate to deal with modern taxation. And in Action 1, it has been admitted 10 times that existing rules are inadequate, that the definition of permanent establishment is inadequate, a significant change in the law is required. All this is discussed. This is this Action 1 report I have downloaded, got it bound. It's a 300-page report. And 300-page report you can't read in 300 minutes. It requires a huge discussion, a huge study. With this, my suggestions, or I would put it like this, all the criticisms which I have received on equalization levy, I have summarized, and I am presenting before you exclusively as my idea, not the committee's idea. I am submitting to you as my idea how to take care of all the deficiencies of the existing law. See, the first criticism is, as the chairman also said, that entire burden of tax and the burden of compliance is on the Indian resident payer. Why should the burden be on the Indian resident? This is the first criticism. The next criticism, and these two criticisms are the most important, and I want to deal with both of them. The next criticism is, when a non-resident suffers the tax in India, he must get credit in his country of residence. The way the equalization levy has been drafted, he doesn't get the credit. He may or may not get the credit. So that is the second one. The third is an important difficulty, that essentially in e-commerce taxation, there is a non-resident multinational corporation, or it may be even an individual, as it may be a small company also, but they are dealing with an Indian resident without having any establishment in India. So how do you catch hold of the non-resident? How do you enforce the law? We may pass a law, but how do you enforce the law? This is a big difficulty, a practical logistics issue. Next one, please. As you would have seen in the papers, under GST, within in the month of November only, the government has come out with the rules that a non-resident e-commerce services provider, or service as well as goods provider, selling his goods or services to Indian residents will be liable to service tax. So the service tax has to be paid. Now, it is the same category of businessmen who is target under GST as well as under equalization levy. Now then, can the two departments of the finance ministry work together and avoid or probably minimize administration of the law? So if there is one X who is selling e-commerce services in India, is paying GST also, can the same machinery be used to collect the equalization levy also? This is a query. I myself don't know about GST. I am not an expert. If there is any expert on GST here, and who, apart from dealing at academic level, who does the practice also, the compliance also, if you can make any suggestions, you are most welcome. The fifth point is, which is again a very strong criticism, concept of neutrality requires that e-commerce be taxed in the same manner as the traditional commerce. How can you have a different law for e-commerce? The next 6, if a e-commerce service provider is taxed in India, in fact, this is a very pragmatic issue, a futuristic issue. Supposing we make a full law where equalization levy, instead of being a separate chapter, is merged into the Income Tax Act, then the provision would be under Section 5 or under Section 9. As you know, Section 5 is the scope of total income. It is the basic provision. And Section 9 takes us to the deeming provisions. The BEPS Action Report number 1 talks about significant economic presence. So this significant economic presence concept can be introduced under Section 5 or Section 9. That is the issue. Assume that the non-resident becomes an SSE taxable in India, he files his return of income. Okay. Now, he would have probably a global presence. What the non-resident, just to give an illustration, Google. It is just an illustration because all of us are using Google for its e-commerce services. And Google is earning 5,000 crores from India per year. Google would be earning similar revenues or much larger revenues from 100 countries. How do you attribute the profits to India? It is a huge issue, attribution of profits. These are the 7 issues I am presenting before you, which issues have to be taken care of if we want a complete law instead of this small version of equalization levy. After all of us discuss these issues, at the end again I will come back to you with my own suggestions of how equalization levy can be made into a complete law. Thank you.
Come up with the equalization levy, the unilateral action that India has taken. And a lot has been said about how justified India is, how long India waited, tried to convince others, build a consensus. India is being not unreasonable is the point that Mr. Rahul Naveen and Rashmin Sanghvi has brought out. But let's look at some of the legal implications. So, Mr. Datar, do you think the imposition of equalization levy is something that can be regarded as constitutional, or is the law ultra vires invalid and can it be challenged?
Good morning to all of you. It's nice to be back on the annual tax pilgrimage to Bombay every December. When the budget was announced and we had this new levy of equalization levy, my colleague Sandeep put the question, is it constitutional? And when we went into the question, it appeared to me, and I'll put it before you, the definition says that there will be an equalization levy on such specified services. And if you go to the definition of specified service, it said specified service means online advertising and such other services as may be notified. Now it seems that online service, basically it's a testing process. They want to have the first baby steps of equalization levy. But there is a small hurdle. Fortunately, it's gone away now, but I'll come to that. If you take the Constitution of India, entry 92 of Schedule 7, as all of you know, we have got three lists. List 1 is the union list, and list 2 is the state list, and list 3 is the concurrent list. And one essential principle is all union taxes are in list 1, all state taxes are in list 2, and there is no overlapping of taxes that is permitted. Significantly, concurrent list has no tax at all except stamp duty. There's nothing else in the concurrent list. Now, strangely, and I don't know how the Parliament missed it, the taxes on purchase and sale of newspapers, including advertisements therein, is mentioned in entry 92. So the union taxation is confined to taxation of advertisements in newspapers alone. And if you go to entry 55 of the state list, it says taxes on all other advertisements come in the state list. So technically speaking, taxes on online advertising would be unconstitutional. If anybody challenged it, it would be subject to a serious vulnerability. But the union has been overtaken by events, fortunately. After the 115th Amendment, which has introduced GST, what they've done is they've deleted 92 and they've deleted 55. And now it says that the unique thing of GST is under Article 246A and 269A is that the Parliament and states have the concurrent power to levy GST. The restriction is states can't levy GST in interstate transactions. That's the purview of the preserve of Parliament. So now, digital economy, if I'm talking of within the country e-commerce, it will come within the each state and each the center can levy tax, whether it's an intra-state or interstate, that's a question to be discussed. But if it's an imported service, then it will be the subject matter of levy by Parliament, because they have defined it very well. They have said it that on interstate sale and interstate sale of goods, sale or purchase of goods, only Union of India can levy taxes. And they had an explanation to Article 269A, which says that any import of goods and services shall be deemed to be a sale in the course of interstate trade and commerce. So by a legal fiction, all imports of goods and services are now interstate sales and will be taxed only by the union. So to answer the question, what I would like to say is that today the levy is constitutional, but for the brief period between the passing of the Finance Act and the deletion of entry 92 and 55 by the 115th Amendment to the Constitution, which brought in GST, the tax was seriously suspect. That is the position. Now what happens hereafter? Just briefly on constitutional. Hereafter, there is no constitutional challenge to the levy. In my opinion, it will be perfectly valid for the union and the states to levy taxation. So the constitutional challenge goes. The only thing you have to note is that we are, as the draft law as it now stands, the taxation of goods and services which are imported will come under IGST. And if you take section 4 and 5 of the Draft Act 2016, the tax will be levied at the place where the goods finally land. That's the recipient of the goods and services will be the place of supply of goods. So if I'm in Mumbai, and the goods come into India and come into this in Mumbai, that will be the place of supply. So imports will be subject to IGST. As far as the intrastate will be subject to SGST, and interstate will be subject to CGST. All this is simplified law, by the way. In fact, the irony of it all is the union touted as GST as one tax, one nation. And if you now see Article 246(8), technically, believe me, each state can levy its own SGST. Each state can levy it. So it's going to be one nation, 29 states, 29 taxes, and that is simplification. Now, and there is a problem here. I don't know how they're going to solve it. You've got a model law. Under the Constitution, you've got the Goods and Service Tax Council, which can make recommendations. How much time do I have? Yeah, 2 more minutes. Yeah, they can make model laws, but there is nothing binding on the state to accept that model law, because under the Constitution, under a federal setup, within the states, within the jurisdiction given to the states, each state is plenary and sovereign in its own right, and that has been reaffirmed by the 9 judges bench recently entry tax. So if one state decides to go in a slightly deviant route, there's nothing that the government can do. So and the more there is deviation, the more there's going to be distortion. So as far as e-commerce is concerned, I really hope and pray that there is a national consensus that the entire law which is made will be uniform and no state will take a deviant path. So to answer the question, it is perfectly constitutional. And now let us see how it pans out. For imports, you'll have IGST. For interstate, you'll have CGST. And for intrastate, you'll have SGST. Thank you.
Thank you so much, sir. That was very illuminating. So fortuitously, what started as an unconstitutional equalization levy, now it turns out can be defended under the new constitution amendment, which incidentally was made without even realizing that it will make this law constitutional.
Chairman, sir, please, you can't make that statement because the committee had taken opinion of a solicitor. I have got the written opinion that even in February, the equalization levy was constitutionally valid. So we have a difference of opinion here.
Excellent. I'm only summarizing what Mr. Datar mentioned on the panel.
Okay.
I'm no expert on constitutional law.
Incidentally, I just mentioned when we had a discussion yesterday, I found out that Rashmin was one of the chief architects of the equalization levy. So I've been calling him Dr. Babasaheb Ambedkar of this particular levy.
And Dr. Babasaheb Ambedkar drafted the constitution. So if you are Dr. Babasaheb Ambedkar, then everything is constitutional. Right. So anyway, the way I have been made to understand right now at least is that what was probably not constitutional became constitutional only because of a law that got passed, a constitution amendment that was made for the purpose of introduction of GST. Unknowingly, this has become constitutional. But can something, Mr. Datar, which was unconstitutional when enacted, just to understand, can it automatically become constitutional because of a subsequent amendment in the Constitution, which I assume when that amendment was made, the objects and purpose of that amendment was completely different?
Well, you've drawn me into a controversial debate because there's a difference between, you see, a law can be unconstitutional for lack of legislative competence, and a law can be unconstitutional for constitutional limitations, like it can't violate fundamental rights, can't be unequal, it can't be restriction on trade and business. So that's violation for regard of constitutional limitation. But if the law is invalid for legislative competence, what happens? The Supreme Court has said that if a law is invalid for legislative incompetence, then it is void ab initio, it's like a stillborn child, the law has to be freshly enacted. But with all humility, I beg to differ because they have taken a US concept and I don't agree. According to me, when the law was drafted, we just assume that the solicitor is wrong and I'm right for the time being. So, when the law was drafted, it was unconstitutional. Why was it unconstitutional? Because entry 92 said union can tax only advertisements in newspapers and the states can tax advertisements, other advertisements. So once that is said, as per H.S. Dhillon's case, entry 97 doesn't come into the play. If a subject matter is a state subject, it is completely taboo for the union. So it was invalid for legislative competence. According to me, the doctrine of eclipse applies here also. There was a limitation on the union's power that they could not tax advertisements other than those in newspapers. But that limitation has been removed by the 115th Amendment, and therefore the law is valid. In my humble opinion, there is no need to reenact the law, because when I'm working on my constitution and I'm writing out the thing as to how that is not correct, there are two judgments which have said there is no need to reenact the law. What was invalid because of a particular defect, once that defect is removed, it becomes valid proprio vigore. As it's very nice to use Latin expressions, sound very learned. So it becomes valid from the beginning.
Excellent, sir. That was Greek and Latin, but anyway.
I spoke in English.
Right, sir. We will move on to the next question. If it is constitutionally valid, let's try and understand from Padam. Is this an income tax? Is this an indirect tax? Or something else?
If you had listened very closely to Datar's exposition, he never made a reference to entry 82, tax on income other than agricultural income. He never made a reference. To him, it was a non-issue. To him, therefore, equalization levy is an indirect tax only. Otherwise, he wouldn't have avoided entry 82 at all. To him, therefore, it appears to be entry 92, entry 55, entry 97, therefore, it is an indirect tax. The terms of reference to the e-commerce committee is very interesting.
Can I interject you for a moment?
Yes.
Does it mean that if something is not an income tax, it is necessarily an indirect tax? For example, gift tax, wealth tax, estate duty. These may not be income taxes, but they are not necessarily indirect taxes.
They are a part of the direct tax regime. And this was what Datar had explained yesterday. The difference between direct tax and indirect tax is on the aspect of passing on the benefit to somebody else. If you pass on the benefit to somebody else, possibly it will partake the character of indirect tax. If you are bearing it or having the burden on yourself, you make it a direct tax proposition. And therefore, the references are, therefore, you become the part of the direct tax regime. And I was making a reference, therefore, that Mr. Datar was mentioning about the inclination of this law towards an indirect tax proposition or a culture. The terms of reference to this committee are very interesting. When the board appointed this committee, and I will read the portion in the press note also later after the committee gave its report, that to examine the business models of e-commerce, identify the tax issues in relation to e-commerce transactions and suggest an approach to deal with these issues. Therefore, interestingly, the tilt of the committee was to go towards the direct tax issues and identify those issues and make recommendations vis-a-vis the direct tax issues that you have identified. Very classical battle of the heart and the head. Heart was moving towards the direct tax proposition. Head is saying, if I were to move to direct tax propositions, I have a lot of problems with me. I will have too many changes to be made to the domestic law, to the treaty obligations. And therefore they said, no, I need to stay away. Heart says it's a direct tax, but mind says it has to go to indirect taxes. Therefore, the controversy was that you need to create wealth, and that gives you the source theory. You're now asking not where the source is, you're not asking what the source is. You're moving therefore into a change concept to say from where the source is to what the source is. Source is an origin of wealth. I therefore put in my efforts for the purpose of origination of this wealth concern, and that's the concept where the origin of wealth is. Law is moving slightly away to say, no, not the origin of wealth. Who is a contributor of this wealth? Somebody is a contributor of this wealth. We will therefore levy a tax on a person who is contributing to this wealth creation. Therefore, it's very interesting to say the battle between the heart and the head is causing these ramifications and this controversy whether this tax is a direct tax or an indirect tax. I will draw certain references to direct tax because Meyyappan will deal with the indirect tax propositions, and I will therefore confine myself to say what are the characterizations or what are the features available to us to say that this is direct tax apart from the terms of reference to the committee. And there are three stages to discuss this issue. One is the BEPS action plan one itself as to what they had to say in relation to this item concerned. Do we get indications from that BEPS action plan to say that we are veering round to a direct tax proposition? Then there is the committee report, it has its own observations, and then we have ultimately the statute which has been enacted to say what are the provisions that will concern the equalization levy. And therefore, in these three aspects, we'll find out are there any indications to say that this is a direct tax levy. Coming to the aspect of the BEPS committee, we therefore find out in the BEPS committee itself as to what they had to say. They said, we are recommending three measures, and all these three measures were in direct tax concept. Change the definition of a permanent establishment, have a withholding tax, or have an equalization levy. These are all in the context of direct tax provisions only. And to recommend this, either the alternatives, they said, we are now trying to eliminate a distortion between a person who is going into a country, operating his business there and making profits and being liable to tax there, with a person who is staying away from that country, earning the same income and not paying taxes there. Therefore, the analogy was a person who was present in a country, earning income, paying income tax there, which is a person who did not go into the country for the purpose of discharging his tax liability. And therefore, they said, to get over this distortion, we are recommending these three situations concerned. And therefore, the whole focus was towards the direct tax aspect. They also said, we are going to look into the aspect of the economic presence, substantial economic presence, and what is the value creation that is happening in a particular jurisdiction. Value creation, substantial economic presence are direct tax propositions. They are not exactly indirect tax propositions. Therefore, if you go into these aspects from the BEPS committee, you find that the focus or inclination was towards the direct tax inclination of this levy. What did the committee talk about? The e-commerce committee. Very interestingly, page 91 of the committee's report says, we would like this levy to be as close to a deemed profit taxation. So therefore, we are suggesting the 6% measure, which we think would adequately compensate the loss of tax otherwise that the government would have had to bear. And therefore, they made a statement. This has to be as close to a deemed tax on profits of those persons who avoid having a presence in this country concerned. The committee did recommend that you need to have a mandatory clearance under 197 such that you are able to say that the income earned by this person concerned in relation to which there is a discharge of equalization levy, the ITO should be obliged to give a 197 certificate to say this income has suffered taxation in this country and therefore you shall get a mandatory certificate of nil deduction under Income Tax Act because this has to be considered as exempt in the hands of the person concerned. And therefore, this was also a situation where the committee gave its feeling that it has to be a direct tax levy. Look at the law in Income Tax under the Finance Act as finally enacted. The finance minister, when he made his speech in the parliament, he says, I am levying this equalization levy to tap the tax on incomes earned by these e-commerce players concerned, to tap the income on the incomes earned by this e-commerce transaction. Same thing happened in the memorandum explaining the provisions of the finance bill. This was recorded, and they also said, we are going to impose an obligation to deduct tax at source. They didn't say you have a levy. They said we have to deduct tax at source from the payments made to the non-residents concerned, indicating therefore that it was towards the equalization levy being a direct tax proposition. Look at the definition, and that's extremely important to go into section 164 of the equalization levy, which says all terms not defined in this equalization levy shall have the meaning assigned to them under the Income Tax Act. And the definition of equalization levy says equalization levy means a tax on following blah blah blah. Equalization means a tax, levy means a tax. This word is not defined. Go therefore to the Income Tax Act. 243 defines tax to mean income tax only, nothing else. Tax means income tax including a surcharge thereon. And therefore, the law when you look into this aspect would indicate that with 164 that this is a tax, therefore having the characterization of an income tax. Look into further. What does the law talk about? The procedural aspects in relation to the collection recovery mechanism, because this is extremely important to fulfill the obligations concerned. Not just there has to be a subject of charge and the charge being defined, you should also have appropriate collection and recovery mechanism. Section 220 and 229 of the Income Tax Act are bodily lifted and been made applicable for the equalization levy. The authorities who are going to administer this act are going to be the income tax authorities, and therefore we have a situation where from the administration angle also, we have a income tax authorities and the income tax philosophy and income tax provisions coming in for the purpose of saying that how we are going to have a charge, collection and levy. Section 1050 has been enacted to say that if you have suffered equalization levy, to avoid double taxation, you shall be exempt from income tax. That means they are saying Otherwise, they would have said you are going to be exempt from income tax if there's to be a indirect tax levy. They are saying you shall be therefore exempt from income tax if you have shown to us that you have discharged the equalization levy. And therefore, if you go into all of these situations concerned, one impression that one gets is, although there has been a deliberate effort to say that it should stay away from income tax, we do get a feeling it may not directly be called an income tax, but necessarily and evidently it is a surrogate income tax only.
Thank you so much, Padam. Yeah. So at least there's some clarity now. We are told that this is nothing but an income tax. Any? This is nothing but an income tax.
Surrogate income tax.
Surrogate income tax.
Income tax means there is a difference. There is a difference between surrogate and
No, I understand.
In most treaties where it will become relevant, any substantially similar taxes will be covered. So I guess surrogate income tax will also be income tax. But before we get into that, Meyyappan, would you like to add any perspective very quickly on whether this is an income tax or indirect tax in your view?
So I'll be dealing with more on the international, perspective on whether this will qualify as an income tax or not. Now, if we look at the term substantially similar under our DTAs, it does not necessarily restrict itself only to income tax. It says any substantially similar tax will qualify for treaty benefits. Now, when we look at the global jurisprudence on this, and this particular phrase has been interpreted in many judgments, including the Kincha judgment in Australia and New Zealand. And what the jurisprudence tells us is they will look at 3 or 4 factors to determine whether it's a substantially similar tax or not. And the different factors are, one of the things is they see is that what is the timing of this tax with respect to the other taxes that are imposed at that point in time. So for instance, we have the equalization levy and we also have the GST or the expansion of the service tax network at the same time. So if you see that in that context, you will have an indication on that factor that this is more of a substantially similar tax. The other thing that you will also look at is the method of administration of the tax and what the tax actually seeks to target. So here, admittedly, it's been called a direct tax, but that is not an income tax, or at least the intention clearly is to tax untaxed income. And the administrative machinery is also under the Income Tax Act through reference to the Income Tax Act machinery provisions. So taking all this into account, I would say that it is a substantially similar tax that is subject to DTA.
Thank you so much, Meyyappan. So
There are certain indications available under the statute to say it is indirect tax. Under the statute, we have made a reference to direct tax. What are the indications available to us under the statute to say it's indirect tax? Indirect references. 40A2, which says income tax shall be disallowed. You have no amendment there to include equalization levy. Otherwise, they should have said 40A2 income tax should have been amended to include the equalization levy as a matter of disallowance. They only said 40A1B, if you don't discharge equalization levy, the subject matter would be the disallowance of the expenditure concerned, indicating thereby that it is indirect tax. 115JB defines what a tax is. And they say when you compute a book profit, you add back these items concerned. You don't have an amendment there to say that equalization levy will be a part of tax to add back. And therefore, equalization levy for MAT purposes will be allowed as a deduction. We also get an interesting situation therefore when 48.2 is not referred to for the purpose of including equalization levy. Naturally, therefore, 43B will come into picture to say that if this equalization levy for some reason is not discharged by the SSA concerned, then there will be disallowance of the sum by virtue of the invocation of the provisions of section 43B. That's another issue.
very good. Thank you so much. So as we see it, the BEPS Action Plan 1 report very clearly does not recommend introduction of a levy called equalization levy, but does give us 3 options, one of which is equalization levy. And that seems to be the window of opportunity under which India seems to have said there is an option available, although may not be recommended. And here's our introduction of equalization levy, which is perfectly harmonious with the BEPS Action Plan 1 report. But the same Action Plan 1 also does say that it should not result in the introduction of equalization levy should not result in breach of a country's treaty obligations. Does this introduction of equalization levy amount to a breach of India's treaty obligations, especially if all the speakers here seem to be feeling so far that it seems to be dash income tax, whatever that word might be, right? And let's go over, and first Rohinton has not spoken at all. So Rohinton, what do you think? Does this amount to a breach of India's treaty obligations?
I'll carry you with the proposition of the headless heart and the heartless head forward, based on the hand that we were dealt with as part of the conclusion that was in action item 1. So essentially, we could introduce a equalization levy, but we could not go against our treaty obligations. So therefore, the committee had a very fine line to walk on. They could come out with the equalization levy. And remember, equalization levy as a means of taxing e-commerce is just a means of collecting the tax. It does not really address the root of how we should tax e-commerce. Today, the way we tax companies, foreign companies that have a presence, is through the PE standard. Yes, perhaps the PE standard is inadequate to currently tax the way business is carried on by e-commerce, but there is no viable alternative and on the table and being discussed as of date. And which is why potentially action item 1 concluded that perhaps we should wait for the other action items of BEPS to kick in, and let's see the effect that it has on e-commerce, and perhaps e-commerce is just a bad nightmare and might just go away at the end of 5 years. But this is something that we'll probably get to see. And the big bogey in the room is perhaps the United States and what they will do on taxation as this new government comes in. If I were an international e-commerce company facing the advent of equalization levy in India, I would have 2 options to look at. And perhaps after I looked at those options, I would probably ask my customer to simply bear the tax. And the reason for that is as follows. The first option that any MNC looks at when they have a tax that is being paid in a foreign jurisdiction is the ability to credit the tax. Clearly, and because of the work that the committee has done, they have amply dashed the income tax to ensure that it's not covered by the treaty. And immediately what that does is it closes a door at the home jurisdiction of the MNC because they can't credit the tax.
So sorry, Rohinton, just to interject. Therefore, are you suggesting that in your view, this is not an income tax or something substantially similar to an income tax, and therefore there is no breach of India's treaty obligations?
I'm not suggesting that. I think the jury on that is still open. The reason is
your view, please.
My view is that it's possible that there could be a treaty challenge to this particular tax, the way it's currently worded. But because of the work that's been done to ensure that the doors close on the credit, it's highly possible that multinational corporation will not be able to claim a credit because it's simply by law, as it stands now, is not a tax creditable under the treaty on a first reading of the treaty. The next thing that a MNC would try to do is to try and deduct the tax. And again, that depends on domestic law in that particular country whether they can deduct the tax or not. And the last option that is available is to say, hey, this is the cost of doing the transaction. Mr. Customer, if you want to continue working with us and availing of our services, please pay the tax yourself. And that's what's happening across the board in almost all the cases. Remember the one service that's actually been considered for the test of the equalization levy is advertising service. This advertising service is in the hands of maybe 2, maybe 3 big players in the industry. And they have the power to actually go and tell their customers to take a hike. So it's possible that what's happening today in the market is that these customers are actually ending up taking this as a cost of the transaction. Now, this is okay if I'm a big customer and I have a lot of money and I can bear the additional 6% burden. But what this does is it also kills a lot of the low-level startup business that is big in India, at least at this point of time. And that's an area where the government should look and see if they can alleviate that to some extent. With this, I'll probably hand it back to Pranav.
Thanks so much, Rohinton. Mr. Rahul Naveen, very, very quick perspective on what's your feel on, because I'm sure you all would have considered this in great detail. Do you think there is any risk of this being regarded as breach of India's treaty obligations? I'm sure your answer will be no, but the reasoning might be really helpful for us, all of us.
I think we should see it from a broader perspective. That I think there is a consensus that there is a need for taxation of digital economy, income from taxation of digital economy in the source country. Now, how to go about it? And the BEPS action plan has given three options. The first option is that you change your definition and have a new nexus based on significant economic presence. But suppose you change your domestic law, so it will not help because certainly it will be violative of the treaty provisions. So it will not work. The second option was withholding tax on digital transactions, so that will also not work unless the treaties are revised. So this is the only way, this is the only option which was available where the government could come up with a taxation and claim that it is not violative of our treaty obligations. Okay. Now there can be two views about this, but let us see it from the practical perspective, because a lot of you now it has started and you need to consult, give your advice to your clients. So what advice you will give? Like whether you will give advice to challenge it and not pay, or pay, and then maybe ask the country of residence to give credit of that. So that is the solution from a very practical perspective. So I'm not going into a very legality, and I agree that there could be two views possible, but from a practical point of view, I think we should move forward in this way, that okay, India has a right to tax it, and then maybe you can request the US tax authorities to give credit of this taxes which has been levied in India. So
thank you so much, Mr. Naveen.
So I
would request Pascal to give his perspective on this from the point of view of what he feels about the possible breach of a treaty obligation from India.
Thank you, and good morning to you all, and very happy to be to participate to that panel. And guess what? I will not respond any of your three questions. I'm a guest. I hear the internal debate here, and that's quite fascinating. What I would like to say from the perspective of the OECD is the following. I mean, when I say OECD, I should adjust it. The inclusive framework for BEPS implementation, it's in the OECD, but we have 100 countries on an equal footing. One of them now for a few years is India. So, I mean, when I say OECD, please take it as the global tax community, right? Action 1 was, as you may have noted, number 1, and that was not by accident. It's because the political attention paid to this issue is extremely high. And I can even tell you that there was a negotiation at some point on which action it would be, and it was decided at the end that it was action 1, and I can tell you that at some point the US delegate regretted it badly, say, well, we should have never called it action 1, but it's action 1. And what does it say? It says a few things, and you've mentioned the GST/VAT. I think one of the main outputs of Action 1 will be, and we'll see that in the long term, on the VAT. And I'm glad to see that India is moving there and has drawn on the recommendation on Action 1 to deal with the B2C and destination principle there, which is something nobody pays attention to. I mean, you have hardly mentioned it, and that will be the main thing. That said, So there is another dimension, which is BEPS, to say BEPS is exacerbated in the digital economy, and we'll see whether the BEPS measures address this or not. And the main point of debate, as we've heard here, but everywhere else, is, yeah, but these companies are making profits, they're not physically present, or if there is a physical presence, it's very limited, and therefore we cannot attract as much profit as we would like to attract because there is something wrong there. And this feeling is very widely shared. Is it reasonable or not? I don't know yet. I mean, clearly for some actors there is the feeling that something is wrong, and I would share that feeling. For some others, question mark, and what are today's business models? I mean, the impact of blockchain, the impact of artificial intelligence and all that, 3D printing. I think we've not yet been all the way, and we don't have all the consequences. I was yesterday or the day before, I'm a bit lost in travels and translation, but I was in Berlin at the G20 meeting, and I mentioned that in the afternoon. And I made a presentation to the G20 deputies, so the finance ministers' deputies. And one of my examples was Uber, to say, well, where is the value created and how much tax should be levied on the income, on the profit. And when just after the presentation, I went on Twitter and I saw an alert saying that they're losing a lot of money worldwide, and the losses are extremely big. So you wonder, well, will there be a fight to get the losses so that they can be carried forward on the way forward? I doubt it. So after this development, the point I would like to make is, one, as you said, on this critical issue of the taxing the profit of these companies, and these companies, I don't exactly know which ones we include there, but these new tech companies, this question remains highly political. And it's not enough to say, well, there are losses, or there may not be as much profit as you think, and maybe the revenue will be in the VAT. But the question is here, one. Second, the BEPS Action 1 was not conclusive. As you said, it doesn't recommend anything. It recognizes that there are options which could be further explored. And in that context, countries can do what they want. But as shown by this panel, when they move and that there is no multilateral solution, you face a number of constraints or a number of challenges. I mean, compatibility with tax treaties. If we don't have this multilateral approaching, if you need to do this, these are the changes which would be needed in tax treaties. And that may not be something which would delay the response unduly, because with the MLI now we can amend the bilateral treaties quite quickly if we want to do so. So the debate which will take place is whether we try to move from some options, which are not recommendations, to recommendations. But for that, you need all the countries to be on board. And today there is a big question mark there. Interestingly, the companies now, which 3 years ago were writing to me to say, well, BEPS is awful, we don't want to hear about that, please keep off. Now are saying, well, BEPS is very interesting, we need to have a multilateral approach, we hate these unilateral approaches, so can you do something? I find this change of perspective quite interesting, and we'll see where the balance is found. My overall view is that the unilateral actions which are being taken largely respond to political imperatives more than revenue collection. And in that sense, it's a bit frustrating, whatever the responses to the questions are. And I would think we would all be better off with a multilateral approach, but that belongs to the member states, these 100 countries. And it's true that among the 100, there is probably one which is more at stake, and I don't know what the position will be there.
Thank you so much, Pascal. I sometimes I've started wondering whether US, when it's putting its foot down versus rest of the countries where the market is it losing the plot? Is it that Uber will suffer losses till 2020? All the losses will be carried forward in the US, and by the time it becomes profitable, you have the taxation in these various countries ready to tap the profits. That shouldn't happen. But anyway, So coming back, let's move on to the next question probably. Sorry, yeah, Saul, you wanted to interject, please.
Yes, I mean, since we're asking Pascal questions, the question was put about equalization levy, but I wonder whether a measure like the UK's DPT is considered less disruptive. I mean, on the one hand, it's broader, as I tried to explain, but on the other hand, it is clearly aimed at BEPS, i.e. it's aimed at what they describe as mismatch arrangements, i.e. Profits that are diverted so that they bear at least 20% less tax in the destination country. So if those profits that are diverted are then taxed somewhere else, DPT doesn't apply. So isn't that kind of less disruptive?
Thanks, Saul. Good question. When I hear criticisms on the failure of BEPS because there would be plenty of unilateral actions, actually, I try to count them, and you have the UK DPT, the Australian DPT, and a few unilateral actions in the field of the digital economy. Now, our position as in charge of multilateral action is to say unilateral actions are not great. We don't like them. Beyond that official response, when we try to look into the impact of such measures, our technical analysis drives us to think that the impact is extremely limited. In a sense, it's a bit disruptive by introducing rules which are not that clear or which depart from what has been agreed on the one hand. And on the other hand, the impact in terms of collection of revenue is not that great. So I'm not sure we're in the optimal situation, and we're rather are in highly political environment there, which is never that great for a tax to be properly designed and sound in its implementation. So you see, I try to avoid responding to your question or which one is the worst or which one is the best. I think the best is really multilateral action, and again, trying to put that in perspective so that we cannot depoliticize this debate, but trying to make it more evidence-based and how much money is where for what is at risk. I think we probably would gain continuing that debate in a relaxed manner rather than hyper-politicization of this approach. I can mention that because I was in New Zealand last week, I think, or a few days ago, and there is a debate. Well, Australia enacted DPT. What should we do? And the advice from the OECD that I shared with the revenue minister there was, well, think twice, because you may actually look good for a couple of days in your parliament and in the press, but what will the impact be of what you're doing in terms of revenue collection, in terms of really solving the issue? So we're not really recommending to go into that direction.
Thank you so much, Pascal. So very quickly, moving on to the next question that comes up. What is really the rationale for the 6%? And is 6% reasonable? If we look at the withholding tax rates, maybe on royalty, FTS or whatever else, 6% seems very, very tiny or small, or very reasonable and so on. But the question is, if we look at, how this works. So if we are talking of a situation where a company EFCO has been earning revenues from Indian advertisers, online advertisement revenue. And if the revenue is 100, assuming EFCO has a net profit margin of say 15%. If EFCO has a permanent establishment in India, we already said that then probably equalization levy may not apply, especially if the specified services are effectively connected with that permanent establishment. And let's assume for a moment that the profit attributable to the permanent establishment of EFCO in India is 20%. And the question then is, how much would EFCO pay? 20% attribution of profits to India if it is doing sales marketing to Indian online advertisers seems a reasonable attribution based on most Indian precedents. Nothing more than that can be attributed to India. 15% is a healthy profit margin that EFCO might make, but let's go with that assumption. And how does this work? We are talking of the revenue from India, let's say of 100. If the revenue from India were 100 with a permanent establishment, 20 of that revenue is attributable to the Indian permanent establishment. The profit margin of EFCO is 15%. So the profit on the 20 attributable revenue to the Indian PE is 3. In short, the profit attributable to the Indian permanent establishment is 3 out of the overall profit of EFCO of 15. Right? And on that 3, a 40% tax rate would mean a 1.2 of income tax based on the PE attribution principles versus a equalization levy of 6. When will it ever equate? Unless the profit margin of EFCO, for example, is 75% at the net level, it will never even equate 6. So the question is this particular levy of 6% unreasonably high? Or another way of putting it is an MNC, is a US company, for example, better off saying, let's have a PE in India and let's have some activity in India that will put me in a much better position, at least in terms of the numbers, than suffering the equalization levy. And that's obviously a question that can emerge. One doesn't know what the exact answer is, but the next question then is, what is specified services effectively connected with the PE? Obviously, the platform is abroad, everything research, everything is happening abroad, but the sales and marketing is happening here. There's a branch here doing all of that. That's obviously seemingly a permanent establishment which effectively sells online advertisement. The specified service is effectively connected with a permanent establishment. Rashmin, any thoughts on, is this 6%, especially because the 6 has to go up to 8 eventually as per the report? So is the 6% something that was arrived at based on some rationale which we can probably understand a little better?
Chairman sir, in your illustration, you started with one assumption that the MNC makes 15% profit. Then there is a second assumption that profit attributable to India is 20%. Let us understand clearly that when an illustration requires two assumptions, it is storytelling. You can tell one story, I can tell another story. And there can be any number of stories to justify any percentage you want. Now, in the committee, we said on royalties and FTS, there was a time in, say year 75, the TDS in India was 30%. From 30%, we have come down to 10%. There are different treaties requiring 10% or 15% treaty, and the world has accepted 10% as a reasonable rate. And this committee had decided as a theme that we are experimenting with a new law. We want to cause minimum disturbance and minimum harm. Okay. So we said if 10% is accepted and we suggest a rate of between 6 to 8%, that should be acceptable as a reasonable rate. Without telling any stories, we said 6 to 8 is a reasonable rate. Government of India, in this new government, the approach is taxpayer friendly. So whereas we recommended 6 to 8, government has accepted 6%. That is the rationale.
Right. So you think it is better to compare this with the royalty, interest, FTS withholding rate, rather, because equalization levy is an either or with a permanent establishment tax, not a gross basis tax. Even the law says either you have a permanent establishment, pay permanent establishment tax, or pay equalization levy. So if the concerned EFCO were to actually have a permanent establishment in India, although it feels it doesn't need one, that's fine. And probably the lesser the number of activities in the permanent establishment, the lesser the attribution. I'm not too sure how much you would want as the attribution in your story, but how much high can it be to justify a 6% was the point that I was making. Fair that, but you feel this is how we have gone about it compared with royalty withholding tax rate, and 6% is then
Also,
what you feel.
Also, Chairman sir,
Yes.
the SSC always has an option. That is the way the equalization
Agreed.
levy has been built.
Agreed.
If you think 6% is too high, come and set up your establishment in India.
Absolutely, absolutely. My only worry is how will that next question get interpreted? What is meant by specified services are effectively connected with the PE? I hope it does not happen that that is challenged at the ground level as to what is effectively connected, because I don't see even a very high attribution and a very high profit margin of FCO, even then it will not reach 6%. So it shouldn't happen that that gets challenged as to when can the specified service be regarded as effectively connected with the PE. But because let's remember, the platform is abroad, right? So whatever, if it is a search engine or a social networking site, that is obviously abroad. Here it can only probably have some sales, marketing, etc. So will the specified service of online advertisement be regarded as effectively connected with the PE so long as the PE here is doing, let's say, sales and marketing of that particular advertisement? And I hope that gets respected at the field level by all officers. Otherwise, I end up having a PE and then still having a challenge to face from an equalization levy perspective.
You want me to answer or Rohinton to answer?
Yeah, I think if you can throw light, so what do you have in mind when you say effectively connected with the PE? Specified service is effectively connected with the PE.
Well, to me, and this is my personal view, the logical interpretation is that when an MNC is providing a service which is otherwise liable to equalization levy, and to take an extreme illustration, it puts up one engineer in India, marketing salesman in India, and then says that this service attributable to India is 2% of the gross. On 2%, I'll pay up the income tax. So my 100% should be exempted from equalization levy. That situation may not be permitted, and very naturally, so the department may come out with an issue that the balance 98% you pay equalization levy, on 2% you pay income tax.
Now, sir, my fear is exactly this. If this is the view you can take, it's only left to our imagination what view the Indian income tax officials might take.
Yeah.
That's exactly the problem. Mr. Naveen wants to probably interject.
See, my personal view is that this effectively connected business income has been not appreciated by the tax officers, and I would say that in a number of cases, very high-pitched assessments have taken place, and I think my personal view is that the government should come up with clarifications. But coming back to this issue, here, my view would be that if the taxpayer itself says that there is a permanent establishment and the services are effectively connected, and if he can draw the profit and loss account in India and demonstrate that this is the profit which is coming in India and he is paying tax of the PE, then I don't think the tax officers should have a problem. And then they said that, okay, I will not tax it as effectively connected and I will try to tax it as a royalty income or levy, equalization levy, etc., etc. But from a policy perspective, again, I will say that this will act as a catalyst. Maybe this equalization levy may act as a catalyst for the foreign companies to constitute a permanent establishment in India. One, in those cases where traditionally they are having indulging in artificial avoidance of PE. So they will see that if they constitute a permanent establishment, maybe they are better off, because as example, the tax rate, Mr. Pranav has demonstrated that tax rate would be quite low. And the second will be in the borderline cases also, where they have an option of creating a PE or not creating a PE. Maybe they will take a decision that it is better to create a PE and pay a lower amount of taxes rather than be subject to 6% of tax. And constituting a PE is better for the economics in India, because if you constitute a PE, then maybe you would employ some people in India. Maybe you can hire a building and pay rent. So if you are earning income from having economic activity in India, then at a policy level, I think you should also constitute a PE. And if there are two options available, then maybe equalization levy has acted as a catalyst for people to create a PE in India. And I fully agree with Mr. Pranav that ultimately the tax rate would be lower than the equalization levy. Thank you.
Thank you so much, sir. That was very heartening. Very quickly moving on to the next point. Given that there can be various controversies as to whether equalization levy in a particular case applies or not, it would have been good to at least have some kind of mechanism to determine whether a particular payment that an Indian resident advertiser is making is leviable to equalization levy and what portion of his payment is subject to an equalization levy. So one would have loved to have something like a section 195, 197 AAR mechanism to get some advance ruling. There is, however, no such mechanism. Plus, in fact, there is nothing like an assessment. It's like it's so simple, it's either black or white, either tax is payable or not payable. That's the assumption in the law, in the Finance Act provisions. And there's no assessment mechanism, there is no appeal mechanism. If at all, the appeal is against a penalty. But whether a particular payment is subject to equalization levy and what portion of a payment is subject to equalization levy is not subject to any assessment, no right to appeal, only right, of course, then will be a right to a writ under the Constitution. But therefore, if all of this can be addressed, I think it might also go a long way to make things certain in terms of the equalization levy law. Any quick thoughts, Rashmin, Padamchand, both in that order, please?
My thought is I 100% agree with you.
Right.
And we will put a suggestion in the committee that we should draft adequate law to provide for all these issues.
Right. Excellent. Padam, any quick
This
thoughts?
this is important because the same IT department authorities will be administering both equalization levy as well as income tax. And particular payment, especially when you're trying to expand the range of services to be covered by equalization levy, there's bound to be a sort of a challenge whether it constitutes royalty or whether it constitutes an equalization levy. And the attempt of the tax officer would be, why 6%, let me get 10% by calling it as a royalty itself. The same authority therefore is going to have a choice to say, I don't think what you've done is correct, I think my opinion is royalty, and therefore you come to the Income Tax Act and suffer all the consequences. And extremely important therefore that the administrative mechanism is properly in place to ensure that this type of firewalls are built in very well. You don't suffer the consequences of all these aspects concerned. And the other aspect of appeal, we only have a process of an intimation under 168. And therefore, appeal being a statutory right, unless the law specifically grants it, you can't assume that I should have an appeal against a particular intimation being passed. The only thing therefore would be a writ remedy available to a person concerned to say that if I am not happy with the ultimate determination, I should therefore be liable to, I should be able to file a writ. The other consequence is extremely important, and the point is very well made, that you could have a situation where the tax department could say that you have a permanent establishment in this country and therefore I am going to levy an income tax upon you, and therefore the charge of equalization levy gets abated in some manner. We could also have an issue because of poem coming in somewhere or the other. May not be very material, but that's definitely a possibility that poem could trouble us to say that the foreign person becomes a resident in this country and therefore he is a person who is not going to suffer equalization levy, he is going to be taxed on the global income here. You could also have in some extreme situations transfer pricing issues, because when you make a payment from an AE to another AE outside for the specified services, you're going to say this is going to be exempt from tax in this country and therefore I'm not going to be subjected to any transfer pricing scrutiny. Therefore going to give rise to new type of BEPS issues concerned, where people are going to arrange these things in a manner that they take advantage of equalization levy solely to get over the transfer pricing mechanism.
Okay, very quickly, Mr. Datar, do you think this is only the beginning, because there is a possibility that the list of specified services might get extended? So very quick few sentences on that would be helpful. Your thoughts?
Yes, I would like to play astrologer for some time. Because you see, keeping in mind the service tax, when service tax first came, it was on 4 items, then it became 8, then it became 24, then it became 100, 120. Ultimately, human ingenuity cannot think of various services. So they said everything will be taxable except what is exempt. So basically, service tax has become a contract tax. And I was telling Rashmin Bhai also that para 192 of the central government reports lists 12 possible services, and 13th is very dangerous. It says expenditure paid reimbursement also will be taken to be part of equalization levy. So I think by 2020, when we meet for the next conference, we may have an equalization levy. It's possible to say that every payment abroad will be taxable unless exempt. Like you got exemption for cremation, for hospitals and so on and so forth. So like that. No, I just mentioned cremation because somebody told me that service tax is cradle to grave, and I corrected him saying no. hospitals are exempt and crematorium exempt. So after birth and before death, everything is taxable.
Thank you so much, sir. So on that note, may I request you all to thank all our panelists. They've done an absolutely fantastic job.